A patent is a property right granted by the government of the United States of America to an inventor to exclude others from making, using, offering for sale, or selling the invention through the United States or importing the invention to the United States for a limited time. The most important reason for an entrepreneur to obtain a patent is to be able to innovate, invent, without having to disclose information to the public. Many attorneys and legal experts claim that companies would fail to take risks without a patent because direct competitors would immediately imitate the innovation or invention. Therefore, the research and development costs would help the entire industry rather than the company who spent their resources in order to create the innovation or invention. If patents failed to exist, nobody would take any risks. They would simply wait for another company to research and develop a new idea, which costs a significant amount of money and time to imitate it. Patent law covers any person who invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent, subject to the conditions and requirements of law. The term process typically refers to any unique industrial or technical process that is required to produce a certain product. The term manufacture refers to any subject that is manufactured and then produced. The term composition of matter refers to any chemical process that requires creating or altering chemical compounds in order to create a product. Any competent United States citizen is eligible to file an application for a patent. However, this does not guarantee that the patent will be granted. Only about half are. In 2005, the United States Patent and Trademark Office issued official interim guidelines to determine if a claimed patent meets the statutory requirements of being a useful process, manufacture, composition of matter, or machine. The patent claim must also produce a concrete, useful, and tangible result to be patentable. One must file an application with the United States Patent and Trademark Office, which can be potentially a very long and complicated process. However, because thousands of patents are filed each day, approximately 520,000 in 2010 alone, one can use the electronic filing system with ease. With EFS, you can submit utility patent applications, provisional applications, electronic information disclosure statements, patent assignments, computer-readable format, biosequence listings, and pre-grant publication submissions to the USPTO via the Internet. However, even when using the EFS, one will still need to hire the help of an expert, typically an attorney, when creating patent drawings and figures as well as writing the application. A patent application is an official legal document. If it is written incorrectly, it will be rejected or will fail to provide adequate patent protection, therefore defeating the purpose of filing a patent altogether. The United States Patent and Trademark Office issues patents but does not enforce them. Also, because patent infringement is not a crime, it is up to the patent holder to enforce his own patent through civil litigation. Patent infringement litigation is an extremely costly and lengthy process, and the results aren't always fair. The patent owner has the burden of proving infringement on his or her patent, which can be very difficult to clearly and definitely prove. Also, when the patent infringer is a large corporation, they have the resources to afford lengthy and expensive litigation, while the patent owner might be a small business that can't afford the legal process. Most experts suggest that the patent owner hire a patent litigator or patent litigation firm to protect the rights as a patent holder. Although this can be very costly, it has the potential to pay itself off if someone does infringe on the patent. There are 6 major types of patents that are applicable depending on the circumstances in the patent itself. There's utility patent, design patent, plant patent, reissue patent, defensive publication, and statutory invention registration. However, 90% of all patents are utility patents. And a utility patent is issued for the invention of a new and useful process, machine, manufacture, or composition of matter, or a new and useful improvement thereof. It generally permits its owners to exclude others from making, using, or selling the invention for a period of 20 years. This type of patent accounts for approximately 90%. The second most important type of patent is design patent, which is issued for a new, original, and ornamental design for an article of manufacture. It permits the owner to exclude others from an activity involving the design. This patent lasts for 14 years without any maintenance fees. There are many options for an entrepreneur who is concerned about infringing on the patents of others or simply trying to improve his own patent. One can perform a patent search at the United States Patents Office online or in person. However, the most thorough searches are still performed in person at the Library of the United States Patents and Trademarks Office in Arlington, Virginia. The USPTO also maintains libraries in other major cities throughout the United States. Simply browsing the web is another simple yet effective option to determine if an idea has already been pursued. An effective patentability search is conducted by examining patents related to your own idea to determine if it has already been patented. A thorough patentability search has the potential to save an entrepreneur time and money. How much one spends on a patent is directly related to what the patent holder intends to do with the patent and if there is a realistic market opportunity. Patent costs are very circumstantial. It depends on how complex the patent is and the amount of protection that is obtained for the patent. If there is a very realistic chance of applying the patent, one might spend upwards of $20,000 to ensure protection. Patent experts always say you get what you pay for, or the devil is always in the details. Attorney fees are typically in the range of $5,000 to $15,000, depending on the complexity of the patent. The complexity can range from a light switch to an MRI scanner. However, it can cost $125 to file a provisional application and $625 to file a non-provisional application with the United States Patent and Trademark Office. The issue fee is $825 when the application is granted. Lastly, maintenance fees are $565 at 3.5 years, $1,425 at 7.5, and $2,365 at 11.5 years. Maintenance fees are fees that are paid to maintain a granted patent in force. Texas A&M University licensing and trademarks are enforced by the Office of Business Development, which can be assessed at their website. Using their registered symbols or other identifying marks with written approval is prohibited by the university. Registered symbols include, but are not necessarily limited to, all registered marks to the university's names, abbreviations, symbols, emblems, logos, mascots, slogans, official insignia, uniforms, landmarks, or songs. They have a trademark statement on their website that states unauthorized use of the marks is trademark infringement. Such violations are subject to liability by damages, injunctive relief, attorney's fees, and other penalties, civil and criminal. They are very strict about regulating where their symbol is used because it's a representation of the school. If there is ever a violation, it can be reported by email to the Office of Business Development. Texas A&M University uses the Collegiate Licensing Company as their primary licensing agent, which is responsible for licensing many institutions. To get approval to use the school symbol, you must write a formal agreement to get a standard license, a local license, or an internal campus supplier.
Thank you for watching our presentation on patents and trademarks. Shivers is going to be really sad to see you go.